And a very good morning to everybody out there. This is Vinny Maletti with Maletti Law, the strongest name in law. My name is Vincent Maletti. I am the founder, owner, lead partner, Mac Daddy, everything of Maletti Law. The date is, what is it? Tuesday, August 24th, 2021. This is another one of these short little training videos. This one is called The 5 Things That Should Be in Every Confidentiality Agreement to Protect Your Interest. The 5 things that should be in every confidentiality agreement to protect your interest. Okay, so let's get started real quickly. Let's go through the key ideas of what a confidentiality agreement is. So, first, what is it, right? So it's an agreement that's out there, written agreement that parties sign on to protect the confidentiality of the discussions that are happening between the parties, okay? Why do you need it? Well, let's say you're a business owner and you have, you want to log on to this service. You have this really great service you want to connect with, in order to see if that service is, what's the word I'm looking for? To see if that service is useful or something that could integrate with your existing system. You need to have these conversations with them, but sometimes those conversations require you disclosing important confidential information. It might be business figures and numbers, it might be formulas, it might be metrics, etc. So you want to protect that information. You don't want to get out there because it gives you a business advantage, or at least in your mentality it does, right? So it's a legitimate interest to protect. Who uses it? You're going to find that it's used in companies, it's used in private discussions between private individuals. Basically, it's used whenever there's a person or entity that has some kind of confidential information that they do not want to disclose. You see it used in, again, conversations with vendors, maybe with prospective employees that you want to hire, maybe with employees that you're going to give them some kind of, a boost in the company, give them some kind of promotion in the company. That right now, let's say their position doesn't have proprietary information, but they may have proprietary information on the, what's what I'm looking for, on the promotion, right? So it comes up in a variety of manners. Generally, how does it work? It's a contract. It's a contractual agreement between parties. So the contract speaks for itself. The reason why you get into a contract is because you want to plan for contingencies, so you don't have to deal with them in the courtroom, right? So the contract, like a great contract, theoretically, will answer all your questions in the contract in the event of any problems. Sometimes this theory results in having a very long contract. You're always better having a nice exhaustive contract as opposed to a short contract that leaves questions and leaves things out. So, okay, so let's get down to it. The 5 things. Before we go into them, I'll cap them off. Every confidentiality agreement should have an authorized purpose. It should have something about returning data and certification of that return. It should have indemnification. This way you got to stay yourself out of the courtroom. It should have what's known as a non-circumvent, which is usually couched in a paragraph that has non-circumvent, non-disclose, and non-compete. And then it also should have a prevailing parties fees provision in case you got to go to court, because the general rule in America is if you don't have prevailing parties fees in the contract, then you're not entitled to your attorney's fees. So those are the 5 key items off the bat. All right, so let's get down into them one by one. So what is the authorized purpose? That's element number 1. You should always have an authorized purpose. So the authorized purpose is, for what purpose is the party permitted to use this data for? You are giving confidential information. To what purpose are they permitted to use this confidential information? You naturally want to keep this very limited because you don't want to give them an ability to use this information for anything else. So you want to keep your authorized purpose very narrow. If it's a vendor, you want it specifically to what that vendor is doing for you. If it's to an individual that, let's say, you want to give them a promotion in the job, you want to keep that very narrow to just whether or not they're qualified to be in the position to make that determination. So you want an authorized purpose. What is the purpose of this agreement? What is the purpose of giving them this confidential information, this access to it? And how does that help you? And how does this agreement advance that? So that's the authorized purpose, right? So that's part 1. The second one is you want language that discusses returns and certification of the confidential information. So the return and certification of the confidential information. What does that mean? You have your discussions. At the end of the discussions, let's say you realize you can't work together. Let's say you went to a vendor, you want to speak to a vendor about a specific software. You realize that software will not integrate with your system, but during this time you gave the vendor a substantial amount of information, a substantial amount of confidential information. So you should have a provision in the confidentiality agreement that says at the end of our discussions, you will return back that information. You'll return the confidential information, and then you will certify its return by an email or something. This way, A, they're obligated to return it, and B, they certify that they returned it, so you could have something to lean on if you ever had to enforce your rights under the confidentiality agreement. Usually, I would put like a 5 or 10 day, period at most to return it. At that point, you could enforce and you could start asserting breach of contract and everything. Okay, so that's the second element. Now, the third element is indemnification. So this is a hot provision a lot of people, and I will not use a company, I will not use a vendor, or I will not speak to a person that is not interested in indemnification. Here's what indemnification is. Indemnification is a fancy pants term for a legal right for them to do something, a legal right for them to cure you. So it's not necessarily an insurance policy, but because it doesn't insure anything. What it does ensure is if they mess up, if it's something that's traceable to them, if the party messes up and you incur damages, they are required to indemnify you. They are contractually required to cure what the mess up is, to remedy it. It is their purchase, it is their price, not yours. It is their bill, not yours. But you need to be fair in this situation, so you want to attribute indemnification to true damages, right? Something you can reasonably articulate. So you can't say that, all right, well, my whatever, this confidentiality was, the email was accidentally disclosed, and you owe me $1 million. It doesn't work like that. It should be fair, okay, to the other side, and it should be traceable, at least reasonably traceable to some kind of damages or something. So the third element is indemnification. The fourth element is what's known as a non-circumvention. So a lot of these contracts have what's known as non-compete. They have another non-disclosure provision. They also have non-circumvention. I think non-circumvention is important because just by its very nature, non-circumvention means the party is not circumventing, it is not going around the contract to harm your interest or to better their interest in some way unrelated to the contract. So, for example, I give Bob confidential information. Bob takes it, he reviews it in the email, and then Bob prints a copy, right? And he wants to print a copy for our phone call. So Bob prints a copy, and then he tells his admin, hey, listen, I printed this copy. Why don't you take it? Why don't you print it, scan it, send it to Phil, and Phil could use this, and we could do something with this elsewhere. So he's circumventing the agreement by going around his provisions. He's printed a copy, which he was able to, and printed and use it for our phone call to determine if we could use their services. But by giving it to Phil, he's circumventing the agreement in that situation. So a non-circumvention is important. I think every confidentiality agreement should have that clause in there, and I think it'll save you a lot of headache in the future. Finally, the fifth clause that every confidentiality agreement should have is a prevailing parties fees clause. Prevailing parties fees clause. All right, so this is basically attorney's fees, but it's only given to the prevailing party. So in America, in the U.S., the general U.S. rules that unless the contract says otherwise, or unless there's a statute on point, you generally do not have a right to collect your contract damages in litigation. If it's a breach of contract case, the American rules that every party is responsible for their attorney's fees unless the contract says otherwise. So we defeat this, we avoid this by simply putting in the NDA that the prevailing party, the party that wins in court, is entitled to recover their fees. So very simple, easy peasy. Just it's something you got to remember to put in there, because if you don't put that in there, theoretically you lose the right to use it, and then, honestly, bad enough they've already disclosed your confidential information, bad enough you're already struggling to try to probably find, with specificity how those damages are, even if you have an indemnification clause, so you need the comfort in knowing that you can get your attorney's fees back, or some portion of those attorney's fees back, in the event of litigation. So that's important. So those were the five items that should be in every single confidentiality agreement to protect your interest. the 5 items that should be in every confidentiality agreement to protect your interest. And just to give a quick recap one more time of what those 5 items are, just in terms of categories. Category 1, item 1 is having an authorized purpose defined. Category 2 is having a return and certification of confidential information clause. Category number 3 is an indemnification clause, is category number 3. Category number 4 is to have a non-circumvent clause, and category number 5 is to have a prevailing parties fees clause, All right, so again, those are the 5 things that should be in every single confidentiality agreement to protect your interest. This is Mileti Law, the most powerful name in law. Please be sure to subscribe below. Please be sure to follow the newsletter. Always be unusually motivated because we are a unique crew here. And you know the rule. Yours and laws, loves and lifts. If you have any questions, comments, leave them in the below. Again, sure to subscribe, sure to join the newsletter. Have a good day, everybody.